Hey, all present, anything before the honor of the justices of the appeals court of the Boston Bar within the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated. Good morning,
Good morning.
Good morning. Thank you for being here. I'm going to call the first case, although it's not going to be heard today, as you've probably been informed by the court officers and by the clerk. The case is COMMONWEALTH versus NICHOLE MATHIESON, 2024-0122. And we learned this morning that Attorney Archer is ill-disposed and not able to be here. So we're going to reschedule the case potentially or figure out what we're going to do. But we're going to start court today, and we don't have an exact answer for you as to exactly what's going to happen. But we wanted you to know we appreciate your coming today. I understand you had a bit of a distance to drive today, and the weather's not so great, so why don't you go ahead and get on the road and get home safely, okay?
Thank you very much.
Okay, thank you.
Take care.
So we'll move on to the second case on for the list today, which is COMMONWEALTH versus Alexander Henderson, 2024-0162. And before we do that, I'm going to back up for a moment and introduce the panel to you because I neglected to do so. To my right is Justice Robert Brennan, and to my left is Justice Annie D'Angelo. My name is Ariane Vuono. I don't think I need to make very much ado about the preliminaries because I see most people here have been here before. But as you both know, you have 15 minutes to present your argument. We've read everything that you've already submitted, so you can get right to your most important points, and there is no rebuttal in the appeals court. Okay? Thank you. Attorney Weber.
Thank you. Good morning, Philip Weber representing Mr. Alexander Henderson. Mr. Henderson's case is here today because he did not receive the effective representation of counsel. Now, this I feel like is quite clear that the error was not a strategic decision. It was very much an error. Trial counsel himself said that it wasn't strategic. So I think that much is incredibly clear on the record, and the only question is the level of prejudice that this error caused to Mr. Henderson. And in that regard, I would argue that it is quite...
Can I interrupt you just for a moment there? Even though counsel himself indicated that it was ineffective assistance, that's still determination that the trial court makes or that we make, correct? In other words, we could still decide that simply believing that a certificate had been introduced and it wasn't might not necessarily fall below what an ordinary fallible lawyer would do. Right? That issue is still open for us to decide, correct?
Oh, certainly that issue is open. I was referring to the fact that it wasn't a strategic decision, that he didn't do that for some strategic purpose, that it was
I see.
simply
All right, I
an
misunderstood
error.
your point. Okay.
And then thus, whether it's prejudicial enough is very much the issue at hand, thus if it would rise to that level of ineffective assistance for the purpose of a new trial. And obviously I would argue very much that it does, as the issue about the drug certificate very much was, I mean, it was the culmination of this closing argument. The closing argument, a fairly long one, spanned about 13 pages in the transcripts. This part about the drug certificate is the last factual statement that is made. It really was kind of like building up to this moment, saying to the jury, look at this drug certificate, compare it. And the jury, we know, actually listened because they come back with that question, can we see the drug certificate? So they were listening to trial counsel. They were listening to what he said, and their plan was to do what he said, to compare this drug certificate, and that is indeed when it came up that it wasn't actually in evidence.
So even though the drug certificate was not in evidence, there was plenty of testimony regarding what counsel ultimately argued in his closing, correct?
There was the testimony, yes, Your Honor, and indeed that is the trial judge, that was the trial judge's reasoning for denying or stating that there was no ineffective assistance. However, I think that reasoning by the trial judge is erroneous because for the trial judge to think the drug certificate, and well, not the drug certificate, I say the chemist, testified on November 10th. The jury's question was on November 16th, so 6 days later.
We don't know whether they used them, but if you look at the trial transcript, volume 2 at page 44, the judge clearly referred to the notebooks and the notepads and told the jurors to take notes during the trial. So wouldn't that be some indication that perhaps they had something more than just their own memories of this detailed testimony, that they may have had notes, which is what caused them to come back with the question, well, where's the drug cert?
It's a possibility. I mean, we obviously, even if they took notes, we don't know what notes they would have taken. We don't know if they would have known to take notes about those specific things. So that much is, there's an uncertainty in regards to that. And even when it comes to that, because the trial judge took notes. And because when this issue came up, the trial judge wanted to take some time to review his own notes in order to see. And I think it is quite telling that when the trial judge reviewed his notes, he even went through and he talked about a few things, but even said himself that the chemist was going too fast for him to be able to get everything. So he himself, the trial judge, and this is someone who obviously has heard a chemist testify more times than any average juror, is much more used to this kind of testimony with these kinds of issues, and even the trial judge wasn't able to sufficiently say, wasn't able to say with certainty that whether or not it was testified to, because
That cuts both ways, because it's one person, one judge, compared to, as Justice Brennan's pointing out, multiple jurors, each taking different notes, and they can all talk about it, right? So whether, maybe at best the two might cancel out. Is that,
I understand what you're saying. I think the issue there is it's not as though the jurors were coordinating their notes. It's not as though they had gotten together beforehand and go, okay, juror number one is going to take notes about the first few things listed.
No. The point is that they're going to discuss it collectively. They're going to discuss all the evidence collectively and their memories collectively, correct? That's what they're instructed to do.
They certainly are instructed to discuss together. So is there some possibility that these jurors would have taken notes about every single substance? It's hard, that's the uncertainty element of it. It is hard to say with certainty of it, but I do think the fact that even a trial judge is saying the chemist went too fast for me to be able to write everything down, I think it is quite reasonable to think that these jurors also wouldn't have been able to write everything down and to be able to get it down enough to be able to compare that with certainty. And I think that really is a rather significant issue in regards to that.
You say it's all there for us, basically, to see from the judge's ruling and the discussion of the issue once it was brought to the attention of the parties, right? But isn't that why we prefer to have a motion for new trial, so the judge can look and say, okay, from my observations in the context of the entire trial evidence, it was either impactful or not impactful. And here the judge, I suppose, made somewhat of a finding, but really on a different standard and in a different context and on the move with the jury sitting in the box, right?
Well, the reason I brought it without doing a motion for new trial first, Your Honor, is because I didn't feel like filing a motion for new trial would have truly added anything, because we know what happened. There's no question about, strategic decision or otherwise. And in regards to looking at the impact it had on the trial overall, I think that is an appropriate subject for Your Honors as the appeals court justices to be able to rule on. Because the question really is, what effect does this mistake have on the overall evidence? When we're looking at that question, I don't think we need to have that sent to trial, especially since I feel like we already know what the trial judge thought about it, because this would have gone in front of the trial judge. I don't believe he's retired, so it would still go in front of him. So there's nothing to indicate that he would have suddenly ruled differently in a motion for new trial. The issue was brought up, and it was brought up as ineffective assistance of counsel. The words ineffective assistance of counsel appear in the record. So it's not as though there was some mystery as to what the problem was, what the issue was. We knew right then and there, and if the judge at that point had felt it was ineffective assistance, there would have been nothing preventing the judge from taking action on it at that moment.
Did the judge, in the course of that colloquy or interaction, assess the strength of the Commonwealth's case, for example? Was there any discussion about that component?
I don't believe that the strength of the Commonwealth case specifically was addressed by the judge's findings. The judge was really focusing more so on the idea of, this chemist had testified. So I suppose if Your Honors wanted to, remand it for a hearing on a motion for new trial, that is something that could be done. I just felt as though because I understand that it's not the norm to bring this type of claim on direct appeal. I felt that this was one of these exceptional circumstances in which everything had been laid out quite clearly on the record in regards to that, and in regards to the centrality of it, because the jury was already deliberating at this point. So if this had happened earlier, I mean, I suppose it can happen earlier in closing arguments, but if an issue of potential ineffective assistance of counsel had happened early in the trial, when there was still more evidence to present, where there was still more testimony or things to be heard, that would be one thing, but this came up during jury deliberations. The evidence was closed at this point. We already knew what was being admitted, what was in or was not in, so I think it was clear enough from the record to make it appropriate for appellate review in regards to that. And as I said, it really was the centerpiece of this argument, because really trial counsel's strategy was highlighting errors in the police investigation to show that reasonable doubt, which makes it a bit ironic that we're here for an error by trial counsel, but nonetheless, central to that argument was the error shown in the drug certificate, that they showed that we have substances that are not present in the home, then we're talking mismatches between the drug certificate and what is found in the home. I would argue that is quite significant. We're talking a situation in which, jurors listen to chemists. I mean, when we're talking about expert witnesses, these forensic tests that are being done, these are things that certainly carry a significant amount of weight that jurors do take very seriously. So when you have a point of saying, look at the chemist, look at what they have, look at their records, it doesn't match up. The evidence, the science doesn't match up with what was tested in the lab and what was found at the scene. I would argue that that's a very significant factor in regards to what we are dealing with in regards to the overall strategy of the
Do you mean found
case.
at the scene or found within the proximity or under the defendant's dominion and control?
Well, I don't believe there was any of the cutting edges that we're talking about, I don't believe was found at the scene at all. So really kind of goes to everything in regards to that. Because if it was one thing, it'd be found at the scene, but wasn't right near him. But from my recollection of the record, which admittedly is my own memory of it, so I would have to review to say for certain, but my memory is that it wasn't at the scene at all when I went back into it. But again, that even goes to show one of the issues here, that if I'm going based on my own memory, it's much harder to go based on your memory as opposed to when you have a document in front of you that's showing the exact substances.
Isn't that then, in some ways, the very definition of fallibility? You can't be expected to remember everything. You stand up and make a 20-minute closing, you might miss something, and that's why the judge fixed it, and that's why the jury asks. And we don't expect, nor have we seen, at least in my experience, perfection in a case.
Well, I think this goes far beyond just imperfection, as in a slight error. I mean, this is referring to something that's not in evidence. I mean, to build up a closing, to center and argue at this point, and then fail to deliver, there is indeed
The information, you're saying the information was in evidence, just the certificate of analysis itself was missing, right?
Correct, Your Honor. And there's nothing to indicate that the drug certificate couldn't have been admitted to evidence. I'm not really certain as to why the Commonwealth didn't move to admit it, but they weren't required to do so. That's not on them.
That brings up another issue. There was a discussion reported to the judge that the parties could not resolve the issue or something along those lines, that there had been some discussion with respect to what to do about the drug certificate, and that doesn't seem to have been resolved. So there was no motion, for example, to reopen the evidence or to do something at that point in time, correct?
Well, actually, that was brought up. Both trial counsel and the Commonwealth counsel at one point did say to the judge, they both talked about saying that they would like to reopen the evidence. I don't believe it was a written motion, but orally presented, and they said that they wanted to reopen the evidence, and the judge
Said, no, I'll read the testimony if necessary.
Correct, Your Honor. So.
But there was no, all right, that's fine, thank you.
You've mentioned a few times that it was the focus of the closing argument, and I understand about the argument, I've read it a few times, but the actual mention of the drug certificate is one time at the end, and it's talking specifically about the sodium bicarbonate. That's it. So I guess I'm missing why the drug certificate not being in evidence is the focus of the closing argument.
Well, because when mentioning at the end, and I suppose it was mentioned, maybe not at a great length, but it was mentioned
Mentioned kind of once.
In regards to, and I mentioned that as towards the end of it because it was, at the culmination of it. And it was saying, I believe I have the wording here is, if it's so important to have the baking powder, then you test it. you have the can, the powder's there, you test it, look at the drug certificate, sodium bicarbonate. There's no sodium bicarbonate there. They want us to believe, oh, they're diluting the drugs, they're making profit. I mean, it's maybe the words sodium bicarbonate are only said, I believe, the one time, but it is talking about look what's there, look what's not there. And he's saying to them.
What I'm saying is the words drug certificate are mentioned one time in that sentence that you just referred to. I don't think he even mentions drug certificate anywhere else in his closing argument. His argument is about what's not in the evidence. I get that. But your focus on this closing is the fact that he referred to something not in evidence, a drug certificate, and that's the linchpin. It's mentioned one time. So how is that the linchpin of his closing argument?
Well, I would argue that it doesn't need to be, I don't think the words drug certificate need to be said over and over for something to be a linchpin. He was building up his closing, he was building up to this moment, and I think saying, look at the drug certificate, even just the one time, is sufficient to really emphasize to them, look, there's all these problems, there are these issues why you should have this reasonable doubt. Look at the drug certificate. And I don't think it needs to be said multiple times to drive that point home. And the fact that the jury did indeed come back with this question means that they heard him. They heard what he was saying, they considered what he was saying, so saying it the one time was sufficient. I mean, that's like, if the drug certificate had actually been in evidence, this would have been a good closing. It's not that the closing itself was a bad idea, it's not that the closing itself was improper.
Thank you. That was my follow-up question. So if the drug certificate was in evidence, based on the closing, they would have gone and said, yeah, there's no sodium carbonate there. And that would have changed the outcome of the case?
I think there's certainly a likelihood that it would. I mean, obviously, we're talking about things in general. We're always speculating. We cannot say with certainty, but I think there is indeed a high likelihood that it would have caused the jury to look at it and say, we have a mismatch between what the government is saying and what is there. We have mismatch in terms of the scientific testing that is in front of us. I think that is a significant enough issue when you're dealing with science that there is indeed a reasonable likelihood that it could have produced a different verdict. So for that reason, I would say it was ineffective assistance. Seeing the time, I would.
I'll see if anyone on the panel has any further questions. And I see none. Thank you very much for your argument.
Thank you.
Good morning, Justices of the Appeals Court. Michael McGee from the Norfolk District Attorney's Office. May it please the Court. I'll jump right into it. On the record, the judge, after having that discussion, after defense counsel had raised that he believed he was ineffective, found that he did not believe that was ineffective, and that was at volume 6 at page 17. The judge also instructed them to rely on their memory, and that was at page volume 5, 196, and volume 9. And I know your honors have touched on this, but and counsel raised the idea of returning this to a motion for new trial hearing for the first time today. But what is particularly important here is the strength of the defendant's case. This value of a piece of paper after the chemist had testified to it anyway, and the contents of it had little or no bearing on the outcome of this case. This is a defendant that was found within reach of a Clorox container with a false bottom with 73 grams of heroin and fentanyl in it.
What about counsel's argument that the fact that the jury asked to see the drug certificate means that his closing argument was effective on that point? They were asked to do something, they went to find the drug certificate, and it was gone. Doesn't that sort of cut against the strength of the Commonwealth's case, that they were looking for something that defense counsel wanted them to look at?
What I would suggest is that the judge here took care to listen to the audio of the chemist to ensure that the testimony was given about the sodium bicarbonate or the absence of it. And it was, in fact, in evidence, and those are at pages 142 to 143 and 51 of volume 3, and testified to all the cutting agents that were in there, one of which wasn't sodium bicarbonate. And Defense counsel pressed this point that he was worried that he had said that there was a drug certificate in evidence, and the judge said, if they ask, I will replay the audio for them. They never asked, they returned a verdict. So he instructed them twice that their memories control here. He actually specifically instructed that and I forgot the page on it, actually, it was at, I believe, volume 6, page 9, to rely on the testimony about that report, about that drug certificate. So that taken into account, that weighed against the, I'll say, abundant evidence of the defendant's guilt, in particular the cutting agents. Cutting agents were found in the defendant's room. The same brand of Davis baking powder that was found in a trash bowl a couple of weeks or so before, the month before. There was testimony from a drug expert about how cutting agents are used. Certainly, defense counsel was effective in arguing, hey, you never found it in the drugs. And the main thrust of this argument was that his client was using this for his personal use. He made arguments about this works kit and syringes and other items that were around the room on cross-examination and both in his closing. It wasn't that the drugs were there and his client was there. He was arguing simply that he was not a drug dealer. But in the defendant's room were bands, $8,000 in cash, separately banded, scales, a blender with powder around the blender itself, and as I stated before, 73.12 grams of heroin and fentanyl that was next to the defendant as they executed the search warrant, and he was hiding in a closet with some kind of curtain. The Clorox bottle with the bottom cut out of it and 2 separate bags of heroin and fentanyl were in there weighing 73 grams.
Can I ask you a different question? It's really more a curiosity, which is the TrueNarc results. Is that admissible?
I
never saw it.
I wouldn't dare put it in, especially if, I wouldn't dare. You would need someone to authenticate it.
Both the Commonwealth and the defendant would need someone to authenticate it, I presume.
Yeah, and the reason I say wouldn't dare is we have chemists that analyze the drugs subsequent to that, and we typically call them, and that's so to do a preliminary test on the drugs. And rely upon that at trial would really make no sense, because you have a chemist that's analyzed the chemicals and all the dilutants and everything like that.
But if the defendant wants to put in results that show either it says it's something different or it's inconclusive, perhaps as here, what's your sense as to the evidentiary foundation that would be required for that? And have you ever seen it actually done?
Perhaps a judge may use their discretion to give the defense wide latitude to at least argue that there was an inconclusive result before, and maybe call somebody from Thermo Scientific to say that this is what came from the report. Probably not as high a burden as the Commonwealth would have to do to present this as this is what it is.
But there's never been a Dobbin-Lanigan hearing on the scientific reliability of TrueNarc results that I'm aware of, right?
But
we have stuff on PBTs which are out.
Yeah,
but,
I haven't seen it. So I know it's well used.
I'm sorry, finish your answer to this. I'd like to go back to something you said about the judge's, I'll call it a curative instruction to a degree. He does tell them to rely on their memory. Mm-hmm. And in counsel, when he was discussing with counsel, he said, well, I'll play back the tape if they want me to.
Yes.
I haven't read his final instructions probably as closely as I should have. Does he ever mention to the jury that that is even a remote possibility, that there's this? So how are they supposed to know that? I mean, I read his instruction as kind of like, no, you only have your memories, that's the evidence. But he tells counsel, by the way, I also have this tape recording that I could give them. So was that really a curative instruction at all?
What I would suggest is that the judge was taking it one step at a time, which was appropriate here, and counsel seemed to assume it was an appropriate result here. He didn't object to that idea that if they asked for it to be played back again, that
Well,
it could be.
He calls himself ineffective.
And
I don't know what more he can say to.
It's hard, and I know counsel today says it's not strategic, but we don't have a full record before us because this was not before the trial judge on a motion for new trial. So it's unclear to me and to the court what counsel would suggest now, having in hindsight, whether he was that cure, was acceptable to him, whether he still thought he was ineffective after having heard that playback. This is all kind of in the heat of the moment after the Commonwealth has got their full case in with experts and all this significant evidence. The closings are in, and his client's left with this. And I don't want to speak for the attorney. What he was thinking at that very moment about how impactful he felt that certificate was, but it appeared that the judge took very good care to listen to it and explain to counsel that the evidence was in. You weren't ineffective. The substance of that certificate was in evidence.
Can we consider, because it's an ineffective assistance without a motion for new trial, what else counsel could have done? Justice, I think it was Vuono, mentioned there was a discussion, but we don't know what that discussion was. Could they have stipulated to what was in the drug certificate, thereby supporting what defense counsel argued? Could they have tried to reopen the evidence if both parties agreed and entered the drug certificate? Can we consider all those possible alternatives, even though there was no motion for new trial?
Based on all what we have here from the record, all that I would suggest is that reopening or putting in a certificate would have been cumulative of the testimony that was given. What value or whether counsel thinks that would have been an appropriate remedy, we don't know because it wasn't before the motion judge. And what I would suggest to the court is that what is clear is that the judge said that this was not ineffective, and before your honors, there's overwhelming evidence of the defendant's guilt and lack of prejudice to him, even if there was an ineffectiveness.
On the issue of fallibility, correct me if I'm wrong, it looks to me like they rolled straight from evidence into closings. Right? Did they even have a lunch break? Looking to see if they had a lunch break prepared.
No,
They just,
lunch break was later.
yeah,
I'm
right?
sorry,
They rolled straight from last witness into you ready to do your closing argument. Right? Is that right?
Yes.
Yeah, okay, thank you.
My memory is, and I'd have to look at the timer
okay.
on the transcript. I did not.
There was a break after the judge reviewed the
Yes.
testimony.
Right. Yep.
Correct.
And then there was a lunch break, and there was a period of time before the jury actually turned the verdict.
I would suggest that it's the Commonwealth's burden, and the case proceeded, as many cases do.
Okay.
Unless there are any questions, I rest on my brief. Thank you
No
very
questions.
much, Your Honors.
Thank you both very much for coming. We appreciate your arguments, and we'll take the case under advisement. The next case is Commonwealth versus Harold Miller, 2024-0613.
Good morning, Your Honors. May it please the Court, Kevin DeMello on behalf of the defendant appellant Harold Miller. When police stopped and confronted Mr. Miller in this case, they did not have probable cause to arrest him. I think it's important to keep in mind the burden is obviously on the Commonwealth to prove probable cause, but also that there is a delta between reasonable suspicion and probable cause. The evidence here amounted to police observing people with drug-related histories in a drug-related area doing things that they couldn't see. Now, I think we've conceded that might raise reasonable suspicion. It's not sufficient to get to probable cause. The reason is the suspect behavior is just, it's too weak. And it's not an issue of credibility. Obviously, we have to accept the judge's determinations on that point, but rather the weight of the evidence that's being relied on here to determine that there's probable cause at the time that Mr. Miller is stopped. We have, for instance, a suspected past transaction between Mr. Miller and Mr. Doucette. But when you look at the testimony, all that amounts to is they observed Mr. Doucette in a suspected transaction and that he got into Mr. Miller's car. I'd argue that that's suspicious maybe, but is that sufficient to get to probable cause? You've also got, they're talking about no associations with known dealers. Essentially, either Mr. Doucette or Mr. Miller is going to people's houses or meeting with people that are known to police to be dealers. But again, there's no observations of actual transactions or unusual behavior. It's all happening behind closed doors. So again, maybe this is suspicious behavior, but does it really support probable cause? And then in the specifics of this case, you've got, they see Mr. Miller walking into a residence that they suspect is a residence of someone who deals drugs, and then exiting after a short period of time. Again, suspicious maybe, but, is that really probable cause? And, then there's other
As you're gaining speed here, talking about the facts, there was also the fact that your client's car, he parked his car at a certain distance from the house before he went in, and
Sure.
it wasn't necessary, right?
I mean, I'd argue that that's not even suspicious behavior, because he's parking 100 yards away, sure, but he's walking right in the front door in broad daylight. It's not like he's going in a back door. It's not like he's trying to hide his movements. Police are able to see him walking straight from his car into the front door of this place. There's other, behavior that's cited that I don't think is suspicious at all. For instance, Mr. La Rosa moving a backpack from a passenger seat into a trunk. I mean, I don't see what that has to do with or suggests about a narcotics transaction. It's not like
Well, let me ask you this. Assuming, I know your position is there's no grounds for a pat frisk and there's no, they shouldn't be in the trunk.
Correct.
If we were to find there was probable cause, okay, then does the movement of the backpack into the trunk get them into the trunk where otherwise they would not be able to go there? Does that provide some link?
Well,
I know you're not conceding that, but if
No,
we were to get to probable cause, then it seems to me for them to go trunk rather than passenger compartment, you got to have something else.
right, I'm not sure that they have anything that ties them to the car. Look, like I said, how is the backpack related to a narcotics transaction? Is the allegation that he's putting the money in the backpack? I mean, we don't have any indication that that's the case, and if that's what's happening, why is he putting it in the trunk? It doesn't really suggest a narcotics transaction. I think the linchpin in the Commonwealth case is whether or not there's probable cause at the time that they stop him and ask the threshold inquiry.
You're not arguing, and I think the prosecutor alludes to it, you're not arguing that the police have to observe an actual hand-to-hand, right? I mean, there's the cases about the ride to nowhere, et cetera. And the point is well taken, it seems, but I'm happy to hear you respond that if the standard were you have to see hand-to-hand, then any smart drug dealer would never get caught and would be nothing to know where to go with it. And they'd be able to deal with impunity as long as they hide their hands or go in an alley where no one can see them or hop in a car and do a quick zip around the block, right?
Right, so you're right, observing a hand-to-hand is not necessary. However, the courts have observed in the Kennedy case that it is an important factor. It's an important factor that's missing. There's other important factors that the court could look at that are also missing. That this idea of furtive behavior, secreting something in your waistband, putting something in your shoe, the idea of a suspect, reaching into a car. It's sort of unusual behavior, and it suggests an exchange. Here, you don't have any of that. You have basically what amounts to reasonable suspicions. And the case that I would point to is the Stewart case that I think is most like this case. And it's actually one that's cited by the Commonwealth. And in that case, there was a group of people that met, and then a defendant walked away, and he had a backpack. There was something in the backpack that was sort of weighing it down. Police suspected there was a drug transaction because this person had a drug history and this was a drug area. They stopped him. They asked him. He lied to them about where he had been. Mm-hmm. Even then, the court said, that's not probable cause. That's reasonable suspicion, and they didn't have enough to independently get probable cause to search his bag. I think that's a lot like this case. It's not exactly like this case, but I think it's a lot like this case in that police had grounds for reasonable suspicion, not probable cause. They didn't have that sort of extra fact. And you look at the cases where the court's finding probable cause, and like I said earlier, the things that they're seeing are these furtive transactions, this attempt to hide behavior. Mr. Miller's out in the middle of the afternoon. He's meeting people in parking lots in public. He's walking into the front door of a house. This isn't someone who's trying to hide his behavior. Or at least he's not engaging in behavior that suggests to police that this is a narcotics transaction other than, suspicions.
Where do you think this facts of this case stand in relation to Sanders? Sure, that's cited by I think it's cited by the Commonwealth, but. Yep.
So I think it's a different case than Sanders. Let me just quickly look. So Sanders is, the thing with Sanders is that the police observe the defendant reaching into the vehicle. And that's sort of this idea of this unusual behavior that would signal to police that this is more than just a suspicion, that this is probably a drug transaction.
And your position is that reaching into a vehicle is more suspicious or more nefarious or than hop in a car, take a ride around a block, and then hop out of a car?
Well, I think it is because it suggests, it's more along the lines of suggesting that an actual exchange took place. Someone just getting into a car, and I think there's a case, the Levy case, I believe, was cited, which I cited, where someone hopped into the back of a car briefly and then exited. And the court said that wasn't enough. And I think the reason is just someone getting into a car and going for a short ride isn't necessarily indicative of a drug transaction, of an exchange of something, like reaching into a car might be. So I think that's where the distinction lies.
Do you concede that if there's probable cause for the arrest, that this was a proper search incident to the arrest?
I think I have to. I think if the judge is right, and that there's probable cause at the time of the stop, I think they have probable cause to arrest and search him. So that's what I think this whole case turns on. I don't know if Your Honors wanted me to address the Pat frisk. I don't think it's a major part of the case. There's no indication of. It sounds like no. Are there any other questions? I don't know if the issue of consent is something we want to talk about. I don't think it's really there here. If there are no other questions, then I think I'll just rest on the brief.
Thank you very much.
Good morning, and may it please the court. I'm Dylan Punch, 303 certified practitioner on behalf of Middlesex County for the Commonwealth. Joining me at council table is Assistant District Attorney Jamie Charles. The Commonwealth asks that this court affirm the judgment because there was ample probable cause to arrest the defendant prior to and independent of the results of the searches. And the factors leading up to the probable cause in this case revealed that silent movie sequence of drug activity that includes these were experienced narcotics officers. They were surveilling a residence occupied by known drug users and drug distributors due to recent complaints of
Let's talk about that. Why should we give that any weight? These are unknown citizens' complaints. There's nothing about who they are, what their veracity is, what their truthfulness is. Why should we give that any weight?
Your Honor, because the officers independently corroborated those tips by going to the residence and observing this activity that was consistent with drug activity. This is watching.
They didn't see any drugs distributed. They saw people going in and out of a home, right?
Correct, Your Honor, correct.
So what the citizens' complaints were not that people were going in and out of the home. The citizens' complaints were that people were distributing narcotics. So there's no corroboration for that, is there?
Admittedly, Your Honor, that is a different factor in this case. Here, the occupants of this residence were already on the police's radar, so they went and observed, and in their independent experience, knowing that these occupants were drug distributors and drug users, began surveilling the apartment. And at that point, they observed the defendant approach the residence on foot. They immediately recognized the defendant as a drug distributor. They had previously seen him engage in a suspected drug transaction with one of the occupants of this residence. He entered, he briefly left, then he continued on his way. He walked the 100 yards to his car. At that point, he picked up another known drug user, gave him this 100-yard ride. This drug user placed a backpack into the trunk. After this 100-yard ride, the defendant drove to a church. at which point,
Can I ask you a question? Do you agree that if, again, and I know that's not your position, but if we do not find that there's enough on those facts to get to probable cause, that we're a little backed up on the spectrum to reasonable suspicion, that the police had no right to go into the trunk?
well, Your Honor, on those facts, if there was just reasonable suspicion, as soon as the officers approached the defendant and spoke to him and he denied having met with this gentleman in the car, the known drug user, that would be sufficient in the Commonwealth's position to bump the reasonable suspicion up to probable cause.
But assuming that we disagree and we say we're still at reasonable suspicion, we're getting closer but not quite there, would you agree that they cannot go into the trunk, absent a search incident or to arrest?
Yes, sir. If there was only reasonable suspicion, they could not get into
And
the
same as far as a pat frisk. They didn't have, I know you cite the previous firearms charge, but is it your position that they have a right to pat frisk the defendant again based on reasonable suspicion, or again, at that point, be reasonable belief that the suspect was armed and dangerous, or?
Likely not, Your Honor. These were very old firearms charges. I believe they're 20 years old. Apart from that, it was a general statement that narcotics violators tend to carry weapons. The Commonwealth's position is that they did have probable cause at that point, and certainly after the false denial. And I believe it was Commonwealth versus Alvarado, which this court said that can bump it up from reasonable suspicion to probable cause. And of course, when he parks in the parking lot, they saw the defendant go into the trunk where the backpack had been placed by the gentleman who had taken this meaningless ride, manipulating something, they couldn't see what, and it was at this point when they, now they had enough probable cause, they approach him, they open the trunk, they find in the trunk where the defendant had just been standing, they find the cocaine residue, the scale, the plastic baggies, and so the Commonwealth's position is certainly there was ample probable cause prior to any searches occurring, Your Honor.
Further questions? No further questions. Before you leave, I take it this is your first time arguing in the appeals court?
It's my fourth, Your Honor. I interned.
Oh, geez. Well then, I guess you're already a pro. Never mind. Anyway, so I was going to welcome you, but you don't need any welcoming. Thank you both very much.
Thank you, Your Honor.
Okay, I understand we have the counsel for the fourth case here, so we'll call that case next. And that's Paul Conway and another versus Thomas Caragliano and another, 2024-0519.
Members of the panel, good morning.
Morning.
May it please the court, Joshua Siegel on behalf of the appellants, Paul J. Conway and Gail M. Conway as trustees of the Riftwood Irrevocable Trust. The land court committed error in refusing to allow a sufficient opportunity to address the question of whether the Conways, after Conway won here, as owners of the Seventh Shoreway, could narrow and relocate it under the doctrine established in NPM Builders to allow the Conways to continue to use the Seventh Shoreway, to allow the Caraglianos continued use of the Seventh Shoreway in allowed ways.
Counsel, can I start with a procedural question before we get into the meat? Why is this appeal ripe?
Final judgment entered is the short answer, Your Honor. The judgment that entered was such that it envisioned more work, a procedure to determine what work needed to be done, an expensive and I think lengthy procedure.
So the court ordered a plan to be filed, correct?
Yes, Your Honor.
That wasn't done.
A stay was entered also, Your Honor, by the land court.
But it wasn't done to answer the
wasn't
question.
done.
But it was not done, that's
So
correct.
how is it a final order if something that was ordered wasn't done yet?
There was a judgment entered as a final judgment by the land court.
Well, let's back up again. You're calling it a final judgment. But Justice D'Angelo's question to you is, what makes it a final judgment? Certainly not some sort of entry in a docket. It has to actually be a final judgment. It has to, right? And here we have a case on remand. Land court judge says, do X, Y, and Z. In this case, mostly just do X. It's not done. You're not pleased, it seems to me, so you ask for a stay and you ask for an appeal, and you go ahead and appeal. But I'm still flummoxed as to where the final judgment is.
So it's not just me calling it a final judgment, of course. It is just Justice Vey of the Land Court calling it a judgment. And
Point
so,
taken.
Yes, and so there is post-judgment activity that he envisioned, I think, and that was the nature of the Land Court's proposal, so to speak.
So basically, you're saying you're gonna come back again? That we're gonna
I
see?
hope not, Your Honor, but there's certainly a possibility that of course, there's a possibility that there's more to happen. I think the intent of the Land Court.
To follow that up, so if we affirm the order, you go back presumably and file a plan pursuant to the original order. You're not happy with that, you can then appeal what? Can you start over?
I think
Now it's a final judgment?
I think it depends on the nature of the proceedings that follow this in the Land Court. There's a plan that we filed. There will be further dispute over what that plan is. The nature of a plan like this is one that has to be approved by the Conservation Commission and possibly other local boards. It's not my particular area. And then needs to be built. And it's not, for a whole host of reasons, it doesn't make sense to build it and probably could not build it until that piece is also reviewed if it gets that far, but.
I'm not sure you can answer. It's not really a question, but to the extent that Justice Vuono is flummoxed, I'd say I'm doubly flummoxed. I don't understand procedurally how we're here. It just does not seem to me to be the way that we do these cases. I haven't been here all that long, but just because the judge said judgment, even if it's not actually what appears to be a final judgment, we're just going to do this piecemeal?
I hear your concern. I don't know that
Anybody go back and say, wait a minute, before we stay this and take an appeal, you didn't do what you're supposed to do? It makes no sense to me.
In fact, to the contrary, I think Justice Vey, and it's in the record, and I can pull the page if you want, it's toward the end, it said, we have two options. One is we can go through this whole, I can enter a judgment that you can appeal from, and I think that if we had not filed the notice of appeal from a document that said judgment within the time allowed, we would have lost that right to appeal it. And there certainly would have been an argument that if you don't file a notice of appeal from a judgment within the time frame.
Can a judge in a lower court allow you to do an interlocutory appeal to us, or is that something that we have to allow?
A judge in a lower court can enter a separate and final judgment as to part of the claim. And that can be appealed from, and I think that, although not set forth explicitly procedurally that way, that's effectively what happened here. And Justice Vey said, I'm going to enter a final judgment as to this, and you can appeal from that because it's because it's a judgment. He didn't call it separate and final, but it is effectively a judgment. And he said, I'm going to stay the rest of this pending what the appeals court tells me to do, which is in fact what happened for better or worse, in Conway 1 without objection from the court or any party or the Land Court. And the issue that we're here, turning to the merits, I suppose.
What exactly do you want us to do?
So I would like a remand to give the Conways the opportunity to amend the complaint if necessary, but to do discovery and then have factual resolution, whether that's summary judgment or a trial, on whether the easement can be narrowed and moved pursuant to the doctrine established by the SJC and NPM builders. That's what I'm looking for. Because Justice Vey did not give that opportunity here. What was tried in the first trial was a separate issue than this issue. What was tried in the first trial was, as he says it in the beginning of the decision, it's page 618 of the record appendix. Effectively, what are the Caragliano's rights in the easement? And that has been established through the first appeal. And then do the Conways' encroachments into the shoreway unreasonably interfere with Caragliano's deeded rights in the shoreway? And if yes, are the Caraglianos entitled to an order directing the Conways to remove those encroachments and restore the shoreway?
Did the Conways, after our court remanded it, ever ask for an evidentiary hearing or a trial?
Yes, what Justice Vey said at that time was, give me a proposal on what you want to do moving forward. And both sides put in a proposal, the Conway's proposal, which is in the record, and says, we think there's enough here that if you want to rule in our favor and everyone agrees, great, but if not, and we assume not, we would like the opportunity to amend our complaint, conduct discovery on this question because it wasn't right. We're in a posture no one envisioned. For better or worse, what came down in Conway 1 was not anything anticipated by either party or the court when it was previously there. So give us an opportunity to do the discovery we need to do on that, and then we take it from there. If the facts are undisputed, we can file motions for summary judgment. If they are disputed, have a trial on that question. It's not a jury trial, it's a land court. So whether the changes that have been made, or there are changes that could be made that would allow the Conways to narrow and move the easement. The biggest issue that Justice Vey identified in the easement's location was what he called the front of the easement, which is the part between the road and heading down toward the embankment.
Maybe my question wasn't well pointed enough. I know that you requested that in a bunch of requests to Judge Vey. Where did Judge Vey say, no, I'm not going to do that, and you objected and said, no, we need to do this? So there's not an effective waiver on your part.
Well, we made the request, and then Justice Vey said, both parties put in their requests, and then it's page 715 of the record. Justice Vey said, notice is hereby given, the following docket entry has been made. The court has reviewed the parties' memorandums regarding the remand, and then he says what he's going to do and makes a ruling. And to effectively to say, no, you didn't understand what I said, it could perhaps be a motion for reconsideration, but failing to file a motion for reconsideration isn't a waiver. It's that, we propose this plan forward. Justice Vey says no.
Well, I'll put it in the context of a trial. You make proposed instructions to a judge, a jury instruction. When the judge doesn't give that, you have to object. Here, you made proposals, and the judge said, well, I'm going to do X. No objection. No, Judge, wait a second. No, neither one of us wanted that. We want to do this. Is that properly before us?
I think it is, Your Honor. And we are not in a procedure well-defined by the rules of civil procedure. And
Strange case. I think all of us agree in many different ways.
yes, and I submit that the proposal for the path forward, that doing anything more would have been futile. To then, Judge Vey says, I'm going to enter a judgment. Either enter a judgment that you can appeal from immediately, or a judgment that will require you to have, as I read it, have this dispute about the plans, maybe get approvals that then could go stale with the new board in the year and a half you're going up on appeal before any work is done. All of that, I'm going to have you do that. And if I were then to file a motion to amend the complaint at that point, and Justice Vey says, which kind of order do you want? These are the two options I'm giving you. To say, no, I want to amend and I want more discovery, and I'm going to, instead of saying it in the memorandum you requested, I'm going to put the word motion on the top and file it again, I submit would be futile. And that the procedure that the court asked for is the one that everyone followed, and the court made its ruling and said, I give you either a judgment you can appeal from before you spend all this time and effort on work that's likely not going to be, not likely or not, perhaps will not be necessary. The court didn't say likely, of course. That's my gloss at the moment, I apologize. That perhaps is not necessary, or you do the work and then have the appeal on the fundamental issue.
But again, I don't know whether this is procedure or the meat of part of your argument. If you had followed option 2 about filing the plan, wouldn't you have been able to get discovery and litigate that part of the case, and that sort of would have gotten you what you wanted anyway?
That is not how I understood the order, Your Honor. To litigate what work is needed to be done is the way it was put. And we'd already seen the first version of the judgment that was appealed from the first time. And Justice Vey effectively said, I'm going to enter a very similar judgment. And my read of the and litigate what work needs to be done is the litigation envisioned in that, which was not further discovery. It was, you know, we come up with the plan, the Caraglianos say, no, this doesn't do X, Y, and Z, and Justice Fay decides whether the plan we propose or the plan that, or the objections are right or wrong. It did not seem that the litigation that was discussed was another full opportunity to reopen discovery. In fact, discovery had closed. You made that clear at various pretrial matters before the trial years ago. I don't know that that's in the record, those kinds of statements that were in court.
How what you just described is not exactly what's going to happen next.
I'm sorry to hear, Your Honor.
What you just described to us, isn't that's exactly what's going to happen next?
Well, not...
If you prevail, even. I mean, that's exactly what you want, right? You want discovery, you want a hearing, and you want a trial as to what you're going to do and what your neighbors are going to agree with or not.
Yes, Your Honor, and I don't envision that was what was allowed or envisioned. I didn't understand that was what envisioned or allowed by Justice Fay's order in the first instance, because that's what I had asked for. And the answer was effectively, I'm entering the same judgment with the narrower easement
If we were
rights.
to view the judgment as, great, colloquially speaking, give me your plan. Let's start with your plan. For all the judge knows, perhaps, which would be wishful thinking that would be likely, there could be an agreement about what's going to happen. Move that boulder. That's in the sort of in the middle of I mean, there's certain things I think that the parties perhaps could agree on. No, I guess not, right? No, there's not going to be any.
Well, and more to the point, if Justice Fay thought that what we had asked for was what he was ordering, there would not have been the need for this idea of, let me give you something you could appeal from now. Because if he had said, yes, I'm...
That may not have been the best option, to have added that option to number one. But that doesn't necessarily change the posture of the case. But I recognize that that was stated in his option number one.
And if the order was clearly more discovery and other trial, that's not, then, if that was what option 2 was, then there should have been no option 1. And Justice Fay wouldn't have ordered that. That the purpose of this order is, I made a legal decision that I recognize could be, is subject to appellate review, one way or the other. And that legal decision was not to accept the argument that there's more facts, that the facts that were decided are different than the facts at issue under the MPM Builders analysis. And that once Justice Fay made that decision, that was the issue that was subject to appeal. And so I submit that, as indicated earlier, the proper course is a remand with instructions to conduct discovery and a factual inquiry into whether the easement can be shrunken and moved. Thank you.
Thank you. Thank you very much for your argument.
Your Honors, may it please the Court, David Udy on behalf of the appellees. I think there's something that to Justice D'Angelo's point hasn't been discussed yet, and I want to drill down on it because I think it answers the question, and the Court has intimated about this. Procedurally, when this was remanded, the land court invited briefing on the issue of the appeals court order. And the appeals court found that by the derelict fee statute that the appellants owned the fee in the shoreway, but also agreed that my clients have an easement over the shoreway and defined the scope of that easement. It said they had the right to have vehicles go over the easement, they could carry water vessels over the easement.
Couldn't park, yeah.
And the appeals court was very clear that it should be remanded to the land court to determine what, if anything, what encroachments, if any, should be removed. And the court found that maybe all of them could be removed, that the appeals court said that in their order. So what the land court did, number one, was invite briefing on this issue. And in that briefing, and it's part of the appendix, the Conways argued to the land court that because of MPM, none of the encroachments should be removed. Zero, none. And the land court made a determination basically saying, I disagree. Phase 2 is going to be to determine what, if any, encroachments should be removed. Submit a plan. We'll have discussion about it. We'll go over it. Conway's didn't like that. They want the land court to have a trial on its decision that none of the encroachments need to be removed to accomplish the easement's rights. And so that's what they're appealing. And the land court is able to make that determination. Conway's literally filed briefing with the land court arguing, quote, following appeal, this case is now in a posture where the Conways own the 7th Shoreway, and the Caraglianos have a limited easement permitting them to pass and repass over it by foot and vehicle, including to transport watercrafts. As such, in light of the doctrine set forth in the Restatement 3rd of Property Servitude, Section 4.833, as adopted by MPM Builders LLC v. Dwyer, 442 Mass. 878, 2004, no remedial action in the 7th Shoreway is required. And that's in the record.
Are you reading from something in the record?
That's in the appendix, record appendix at page 683 to
683, just thanks, because it was
684.
fast and I,
Right? So
Not much
they
of an
made this
auditory
same
one
argument
sometimes.
before the land court, and it was rejected. The land court said, no, I don't agree that you have to leave the status quo. Something has to be done. And how could the land court do this? Well, it already conducted a trial in this case. Judge Vey did a view of the property. I was there. We heard testimony from all the witnesses of what they used the 7th Shoreway for. So he has all these facts and evidence with the photographs of what it used to look like before to what the changes were now. He's in the best position to make the
Facts that he heard prior to the appeals court decision.
Yes,
correct?
which easily he could then translate to say, okay, I understand it's a little bit different here. They own the fee now, but I can still make a determination based on these facts whether none of the encroachments need to be removed or whether some need to be removed. He didn't give an opinion as to how much of the encroachments need to be removed. He said we're going to have further evidentiary process for that.
So is what Judge Vey did a final order that's appealable from your position?
I kind of feel like my clients are kind of suffering death by 1,000 appeals in this case, and I think, this matter should be fully adjudicated before Judge Vey. One way or the other, it's going to be, because it's going to go back in some form.
It's going to go back, no matter what we do, for the plans to be figured out, and that's going to be appealable, isn't it?
I would assume so, Your Honor. And so I think that the threshold, the reason why we're here is that the Conways don't like the determination by Judge Vey that he made in a reasoned fashion, rejecting their argument that MPM says no changes need to be made. That's the question that they find fault with. It's not, we should have had more evidence about which encroachments should have been removed. They wanted them all to stay, period. And that's the issue, right? And so Judge Vey considered that. He reviewed their briefing on NPM, and he rejected that. And how could he do that? He has an intimate experience with this property. He was there. He listened to the testimony. He reviewed all the evidence at trial. He's in the best position to reject that argument under NPM.
And presumably, he could order another view or do something else at that point in time when the plans
Exactly.
were presented.
Of course. So, it would go back to Judge Vey. We submit the issue is we would ask this court to say is now dead in the water, the argument that nothing needs to be removed, right? So that argument was considered by Judge Vey. I think it should be rejected on appeal, and we go back to Judge Vey and we go through this process with the plan, and he can make a determination with another view, however he sees fit, and that's reviewable by this court if the Conways don't like it. But he already considered this argument, and the argument that the Conways want this court to adopt is that nothing needs to be done. And clearly, Judge Vey considered that argument. He didn't not allow the Conways to make that argument. They made it in a brief to the court arguing NPM, and he rejected it.
So I see you have not asked for any fees with respect to this appeal.
I have not, Your Honor.
Is that a position that you're going to maintain?
Yes, I'll maintain that, Your Honor. So I'm happy to answer any other questions that the court may have, but we would ask that this be remanded, that Judge Vey's original order that he disagrees with the argument that no encroachments need to be removed, be rejected, and that it go back before the land court so we can proceed with the remainder of his order, his judgment.
Right. All set.
Thank you, Your Honor.
Thank you both very much for your argument. One moment, I'm going to confer with the court officer and see if we have another case ready to go. Okay, so one more.
yeah, good.
Then we're going to call the 5th case, please. And that would be John Doe versus Sex Offender Registry Board, 2024-0200. I remind the parties and ourselves that this case is impounded so that we won't use any of the parties' names. Good morning.
Good morning, Your Honors. Attorney Ethan Stiles for the appellant Doe in this case. The appellant, Mr. Doe, is asking the court to remand this case back for a new hearing before the sex offender registry because the hearing examiner relied on a pseudoscientific factor to determine his degree of dangerousness and risk of reoffense, that being factor 37, the catch-all factor. The catch-all factor in this particular case was used to point out that there was a lengthy period of time between the two offenses in this case, and the hearing examiner considered that somehow probative of the requirements required to establish a level. However, I think it is clear that that factor 37 cannot be used to when you're trying to use a scientific sounding factor to prove your burden, because ultimately the courts have held that we rely upon empirically validated risk factors, and this factor is not. And we know this because repetitiveness is usually considered under the rubric of factor 2, repetitive and impulsive conduct. Now, there's been some developments in the application of that regulation, and the court has marked that development. I think the best case, which is not in my brief, unfortunately, is Doe 221882. That's 101 Mass. App Court 797 in 2022.
Are you arguing that factor 37 is not valid, or that essentially what's happening here is they're backdooring factor 2 with factor 37?
Both, Justice Brennan. I mean,
Okay.
yeah, I say it's backdooring, and I think I may have even used that word in my brief, because factor 2 says repetitive and compulsive, and this factor, as applied, just seems to sound like repetitive in another name. And we have no scientific literature cited, even if it were appropriate to cite, to suggest that a substantial length of time between offense 1 and offense 2 is somehow indicative of an increased risk of reoffense or degree of danger. And we have in Doe 22188 an acknowledgement that the Superior Court, by a decision by Justice Wilkins, held that according to the research behind factor 2, you have to have some sanction for sex offenses in between those two, in between a previous and a subsequent offense, in order for that to have any meaning in terms of predictive power. And we don't have that here. All we have is some measure of repetition that doesn't have anything.
What if we had a situation where there was much more repetition? In other words, your point is factor 37 has not been, in this particular aspect of factor 37, how it's applied here, has not been subjected to any kind of scientific review or empirical review. But if, let's say, there was 15 incidents of sexual abuse or sexual rape, 20 incidents of an underage child, at that point in time, couldn't a hearing examiner simply say, I don't need any scientific evidence, this is repetitive, and this is going to increase the danger of this person? Being released upon release, et cetera?
I believe not, Justice Vuono, and the reason is, if that guy was able to get away with all those offenses without getting caught, without getting arrested,
Oh, he
charged,
could be, well,
et cetera,
okay.
et cetera, then Dr. Hansen says, no, it doesn't matter. It doesn't matter if it's 5 or 52 or 20 offenses. If he's not caught, he doesn't have this, he hasn't been put on notice that society knows about him, and he better shape up his act.
That's factor 2.
That's factor 2.
I'm talking about factor 37.
And if you say that factor 30...
doesn't have the same requirement when we're talking just about, as you described it, the catch-all factor, right?
Well,
so wouldn't that number of prior offenses, whether or not there had been a notification or not? Wouldn't that make a difference?
I believe not, because essentially you're essentially what you're doing, and I'm not saying you personally, but what you're doing is really, you're cutting factor 2 in half. You're saying repetitive without compulsive. And there's an and there, and it's there for a reason, and Dr. Hansen says it has to be there for a reason, that the compulsion has to happen because he can't control himself, even though he knows that society he's on the radar now. And ultimately, that is the distinction, that is what makes him more dangerous, is that he can't control himself, even though he knows that that there may be consequences in the future.
And that's even, I mean, to Justice Vuono's point, even if it's 15 or 20 different victims, as opposed to 15 or 20 incidents with 15 spread over a period of time. You're saying that there's nothing common sense about that, or just that we're an examiner and say, well, you're more dangerous if you've got 20 different children whom you've sexually victimized as opposed to 2 or 1.
Now that I think about it, in a sense, we do have factor 22 that talks about that talks about 2 victims. But if you want to put it on the factor 22, you say you had 2 victims, you had 5 victims, however many victims, you say, okay, that's risk elevating, all right. But then to go on and add this additional factor back later on, factor 37, if you're going through the list, and saying, well, I think this is repetitive, you've already covered that in factor 22. Or in some cases, it may be...
So if the examiner called it 37 when it really should have been 22, what's the prejudice? If they just use the wrong number, but use the same information for the same purpose?
But you see, in this case, he's using both factors when he shouldn't. He should only be using the single factor. And this kind of a factor, you know, if it invokes factor 2, that's a high-risk factor. And that is where the prejudice, I think, is even more than perhaps one of the more generic risk-elevating factors that get listed later on in the regs. So now I know that this claim wasn't made below, and it does fall under the substantial risk factor, but ultimately, on substantial risk analysis, otherwise it's waived. But I would ask the court to consider the argument that ultimately that there is some kind of scientific sounding but not scientifically validated evidence here being used to uphold a risk level, and that his prior attorney, he was something fortunate that his prior attorney did not catch the issue and argue it at the Superior Court. All right, well, Your Honors, if there are no further questions, I would rest on my brief.
Seeing no further questions, thank you very much. Got the last one. Thanks.
If it pleases the court, David Shania for the board. I've been working on this issue now for quite some time. In fact, I'm writing a new brief on it that I'm outlining the whole parameter of the board's position. It also has made me realize why I can't retire. Most people have hobbies like golf or building puzzles. My hobby over the years has been trying to figure out the nuances of the board factors, and I've put a lot of thought into this. Factor 2 never dealt with dangerousness. Factor 2 dealt with risk to reoffend. The problem with the first portion of Factor 2 was, bless you, the problem with the Factor 2, the beginning of it was it conflated repetitive behavior with compulsiveness. And that was the issue all along. Now, I spent 10 years propping that up in arguments about the right to promulgate regulations, but finally it fell. Justice Milkey and I went back and forth on this issue many times over 10 years. In fact, I told him at one point, you finally, after 10 years, were found to be right on this issue. But it's not the repetitive part of it. There's nothing in that factor that talks about repetitive behavior and dangerousness. And since that time, and the problem we've had that since that decision by Justice Wilkins, the court has come out in Doe 496501 and said, we have to make a separate dangerousness finding. And that's an important distinction here because most research has always presumed that reoffending sex offenders are dangerous. It never really talks about the level of danger they pose, but the legislature and the Supreme Court has made it clear the board has to find that as a factor. Now, all the recent research really goes to risk to reoffend. That's what it really focuses on. So the board is now trying to find ways to figure out someone's dangerousness. And again, I think Doe 10800 and Smith versus the Sex Offender Registry Board, which is a 2006 case, are helpful because they say the board doesn't have to have a study for every single factor that it has.
I agree with that point, but when I look at the hearing examiner's decision, there doesn't seem to be much difference between what, I think it's a she cites as factor 22 and what she ultimately finds in factor 37. It's exactly the same thing.
Well, there's two differences. The hearing examiner also focused on the fact that the individual offender, in this case, sexually assaulted one of the victims twice. And I think Commonwealth versus King specifically says that a sexual assault, a contact sexual assault against a victim, it causes psychological harm. And it's only common sense, if you do it twice, you're increasing that psychological harm. So the hearing examiner didn't focus only on the fact that there were two victims. When it came to the second victim, what the hearing examiner said is, this is a dangerous situation because he waited 15 years to commit another sex offense. Factor 29 does not take into factor 22 does not take into account the length of time between victims. It just says two victims, increased risk. What the hearing examiner is saying, this is different. He waited 15 years.
But the hearing examiner says in her last sentence regarding factor 37, I also consider this repeated sexual behavior in relation to the nature and scope of harm to a future victim. That's
Right.
repeated conduct.
Right, and that's on the first victim.
Well, that's not what it says.
Right. But even if you take out the writing of the hearing examiner, the board's position is if an individual can wait 15 years at a time when he is supposed to had a reduced risk to reoffend under factor 29, and under Hansen's desistance studies, after 15 years, you're down to a 2% risk, and you still sexually offend 15 years later, there's an elevated danger there in the future.
So is that the difference here that you're...
That's the position of the board in my argument. The hearing examiner didn't probably elicit it clearly, but I think that's what we're getting at here, that different than someone who commits sex offenses against multiple victims over a short period of time, 15 years went by when he should be at the most recent studies at the desistance level, and he still commits a sex offense.
So as a practical matter, how does the hearing examiner ever get there? It just means 15 years between getting caught.
Correct.
Is that really something scientific? I mean, the difference between 15 years between actually behaving a certain way, which might indicate something, and consistent behavior for which you're only caught twice, separated by 15 years.
Well, you have to keep in mind, in the desistance studies by Dr. Hansen, both the 2017 and 2019 study, he says in both of them, the problem that they have with the statistics is that they don't know how many times an individual committed an offense and wasn't caught.
Yep.
We don't know that in this case. The hearing examiner is hamstrung by the fact that there's no evidence to that. And the hearing examiner is not going to speculate that that's the case in this situation. But I think it is interesting, when he should have been at a desistance level, both age-wise and time in the community, he still commits a sex offense.
What if there was not a 15-year gap? Let's hypothetically say 5-year gap, 3-year gap, 12-year gap. Would you say that factor 37 could not have been applied in the way that it was applied here if it had only been a 3 to 4 gap? That the issue here is that since it was such a long gap, that brought it into a useful information as the factor is entitled. Other useful information related to the nature of the sexual behavior, i.e. 15-year gap. Is that right? Do I have it right?
And I have to say that I had this argument with Justice Rubin last month, and
I have not talked to him about this, so I don't know anything about that argument you had.
And he didn't agree with me. I don't think he agreed with me. I don't
You never know
what's
what's going to happen later. But anyway, so So that would have made a difference, I'm assuming.
I think if you have multiple sex offenses over even a 5-year period, then you look at the type of sex offending behavior it is. If, for instance, an individual is sexually offending against a child and it has a high level of physical contact, as opposed to someone who indecently touches a woman walking on the street, I think that maybe you can start thinking, well, maybe his danger is higher than that other individual. So I think you have to factor in, you have to look at qualitative analysis of the evidence as it comes in under factor 1.33, the introduction to that. And I think the hearing examiner has to make a reasonable qualitative analysis on all of those factors to determine whether or not the period of time alters that whole scenario.
What about the suggestion that factor 37 is just not really a factor? That's sort of the catch-all, anything else factor.
Well, that factor actually exists because the statute 178L, Section 3, requires the board to have the use of other information. It's been confirmed in DO 151564, DO 205615, but more importantly, it has existed in all of the regulations. The 2004 regulations had 2 references to it. I think that statute had 1.38 referred to it, and the risk factors of 1.40, which were a lot different than they were set up today, but that also referred to the catch-all phrase. It's to allow a hearing examiner to look at information, one, either not contemplated by the board, and again, repetitive behavior has never been contemplated by the board separately from compulsion for the application of dangerousness.
Well, hold on, counsel. Now you just lost me. I thought the focus of why this hearing examiner was correct to put it into 37 is because of the time that had elapsed. And I was going to ask you, maybe another factor, if you had your druthers, would be factor whatever, time between offenses. And you had me there. But now you just said it was repeated.
No.
What is it?
I'm actually talking more about the idea of the repetitive nature of sex offending as it applies to factor 37. That, and I guess I conflated those terms together with someone who's got time space between. So I think I was focusing more on the idea of repetitive sex offending behavior, which has been the main focus of most of these arguments. This one has a little nuance to it, which is the time elapsed and the fact that this individual really should have been at a level of desistance. And again, I'm not saying that time between sex offenders. I think you have to look at the facts of each case to make that determination whether it impacts dangerousness. That's all I'm saying. It may or may not, depending on the fact pattern. I think there's 2 different ideas here. And one is, if you repetitively sex offense against one victim, you're causing psychological harm each time. But if you sexually offend at different points in time, it really depends on the circumstances of those cases. I don't think that's an automatic repetitive factor 37 using the idea of repetitive for dangerousness on that specific issue. That's more of a fact-driven.
You're saying it might not apply in that situation.
Right, depending on the facts of the case. So I think there's 2 different
I presume
aspects
not to interrupt, but to be sure I understand, and before your time is up, I presume that there is other useful information that might be presented in a case to a hearing examiner in which it is evident that scientific research would be required to actually rely on that useful information within the rubric of factor 37. Not that that's the case here, and I understand
Right.
that your brother here is arguing that and asking us to consider that, but and you don't think it's the case here, but conceptually, it could potentially be the case, right?
If studies are brought to the hearing examiner on any factor, but factor 37, about its usefulness or its validity, of course, the hearing examiner has to consider that before making a decision on using factor 37.
Now, one other issue that's been raised in this case procedurally is, as your brother has commendably acknowledged, that the issue is waived, that we can still consider it. What is your position on that? You probably mentioned that in your brief, and I don't recall what you said about that. I think you just said it's waived, but if we were to consider it, am I right?
Right.
Okay. You want to elaborate on that at all? Because it seems
Well,
to
my
me that you was
position always
dedicating,
is-
you're postponing retirement to discuss this issue, so that maybe you might want to see something on it.
My
Before I retire in any event.
My position on waiver is that it always should stand, it should bar litigants going forward, but I understand the court has the right to look at these cases in a de novo fashion to determine the hearing examiners whether or not there's been an abuse of discretion or whether the decision was arbitrary and capricious. But again, there was a waiver in this matter, so my position
Based
would
on
be-
your experience, is this a good case to address the issue or not? Or
Probably not. I think I'm more concerned about addressing the issue of the repetitive and 37. I think when I argued 360651, I urged the court then to make a published decision, and they didn't, so there's confusion, and I'm writing my 5th brief on that matter, so here we be.
Okay.
So if there's no further questions.
No, thank you both very much, and we appreciate
Thank
your
you, Your
argument. And last case?
Yes, yes.
Okay. I understand the last case is ready, so we won't take any break, and we'll go on to hear the last case on our list. Case number 2024-0567, which is Valeriano DIVIACCHI versus City of Boston Zoning Board. And just to be clear, before we start, I see that there's a split of time with respect to the appellees, 10 minutes and 5 minutes, so is that correct?
We're going to do 12 minutes for the city, Your Honor, and 3 minutes for our...
All right, I'm sorry, 12 minutes and 3 minutes?
Yes, thank you.
Okay. All set.
Good morning. May it please the court, I just want to remind the panel, there's a motion for judicial notice pending that was filed last year and referred to the panel.
Yes.
I guess I just...
You may address that if you want to, but we'll take that under advisement, but you're happy to address the issue if you...
Sure, just quickly, while this appeal has been pending, there's been 3 more variances granted to another house in this neighborhood, which makes a total of about 16 to 17. The purpose of all these variances is to convert what is now 3 out of 4 properties on one side to multifamily. And so this is relevant to count 1. Count 1 is the appeal of the 8 variances granted to the defendant here. It's relevant to count 1 because under the case law, when determining standing, the judge is supposed to take into consideration the incremental effect of all variances. So it's not just the 8 that the defendant received, but all 16 or 17 together are supposed to be taken into consideration. And it's relevant to the other 2 counts because this is further evidence of the unconstitutional procedure that the city has.
Let me ask you this. If we were to take judicial notice of it, how is it then, could we then consider any particularized harm with respect to you regarding those other decisions?
Well, the particularized harm, the big one is the change in density. All these variances are being used to change the neighborhood from 3-family to multifamily, and the case law is pretty clear that...
I think you're saying that we could figure that out, basically. You don't have to allege anything particular, anything more than it's already been alleged or addressed in the case. Is that your point?
Right, well, I alleged the change in density.
Right, exactly. I'm saying
yeah,
that you would say that you wouldn't have to be alleging anything more. So if we were to accept the motion and we were to take judicial notice, your view is that we have enough in this record to understand what that would mean with respect to you?
Yes, Judge. I didn't just plead it. All the variances are attached as exhibits, A through C of the original complaint, and they're attached as exhibits to the motion. So I'm just not a general pleading. It's a very specific pleading with examples in the record of what the variances are. In terms of using all the variances together, I know the city keeps arguing that I'm alleging a conspiracy. They're trying to make me sound like a conspiracy nut, but I'm not alleging a conspiracy. We have 3 audits in the record that are pled in the complaint with very specific excerpts from the audits. These are audits conducted by the city, and there are very specific quotes from these audits. At one point, the executive director of the development agency says that half their variance submissions don't meet code, but they get the variances any. So this isn't just one case of it's not just a variance appeal as they try to make it sound. I mean, if this court did an audit of the judicial system and you find the BMC clerk saying that, you know, half the probable cause determinations I make probably don't have probable cause, but I issue them anyway because the court can figure it out. Or if you do an audit of the police department and the chief says, you know, half of our probable cause arrests, we don't have probable cause to arrest them, but we do it anyway, and we'll let the court system figure it out. I mean, that's not just one case. This is a whole pattern, a whole municipal practice to use the zoning board essentially as a legislative body to change whatever zoning district they want. And then lastly, if there's no questions, I just want to emphasize that a lot of this is an image thing. If this is West Roxbury or Milton or Weston, no developer in his right mind would go to a city hall and ask for a variance to tear down a single family and put in a two-family, let alone a multifamily. They do this stuff in Austin because as they'll come up here, you know, and say, well, Austin is a garbage strewn and it's got rats everywhere. It's a student ghetto anyway. So changing one house from three-family to multifamily is de minimis. It's not going to hurt anybody. But as Judge Sikora said in his decision, and when he chastised the board, oh, by the way, that's where I came up with the 75-year pattern. I mean, I didn't pull that out of the air. I should have put quotations around that. That's what Judge Sikora said in his decision. This has been going on for 75 years. So,
can I ask a specific question about your standing as a butter or an adjacent abutter under 48 Section 11? So, as I understand it, you live across the street, 3 lots down, but it's still within 150 feet.
No, it's not. 48 Section 11 does not apply to here. I'm not appealing under 48 Section 11. I'm appealing under Statute 665, Sections 11 and 12. This is the Boston zoning code. I am not appealing under 48. I know that's what they're arguing. They're arguing case law from 48. But
all right, but you're not, so that is not something, you're not suggesting that you have standing based on, presumptive standing based on where your property is located?
No, we're correct. I have presumptive standing under Chapter 665, Section 2 and 8, which says that the city has to give notice to all persons affected.
And then on the issue of notice, just going to find my notes here, because I think we have a case that says that the opposite of what you're claiming. That says that the fact that you get notice, that the board sends notice out, does not confer standing.
I believe you might be referring to the Porter case, and the Porter case involved the city of Boston, but for some reason the plaintiff appealed under 48 Section 11, as you pointed out. But again, I'm not appealing under Section 48 Section 11.
How do you get standing then? In other words, just because you received notice, how does that translate into giving you standing? What case do you rely on?
Because the statute, 665, Section 2, Section 8, specifically says that the only people who receive notice are
receiving
persons
notice
affected.
and receiving notice that you could be affected so that you can come to a meeting is not the same thing as establishing standing.
Well, sure, it is under this statute. It's not saying that I could be affected. It says that all persons affected, and they give it the board and
Do you have a case where, and there's an appellate case that interprets the statute as, in the way that you are presenting it?
Well, that's the problem. Everyone that seems to appeal these cases seems to use 40A, and very few. I mean, there's some land court cases that deal with 665, and there's the Shepherd cases in which they specifically said that change in density is enough to establish standing. But for some reason, the difference between 665 at 2 and 8 and Chapter 48 doesn't seem to come up. Not too sure why. As I point out, Chapter 48 was amended back in 75 to add this parties of interest and person aggrieved. Chapter 665 was never so amended. places the burden on the zoning board to give all parties affected notice.
So your position is, so the case is actually, it's Murrow versus Esch Circus Arts LLC. And it says that it rejects the notion that one is entitled to a presumption or to standing because the zoning board mailed notice. You're saying that that was under Chapter 48, and because this is, you're saying under 665, the reasoning there doesn't apply?
Correct, Judge. My memory of that case is that was a 48 case, and the reason you'd have that distinction under 48 is because 40A defines party of interest as abutters to abutters and the person across the street, as long as they're within 300 feet. So in theory, under 40A, if you're in a place like Weston or something where the lots are huge, I mean, you might only have 2 or 3 people that have.
I mean, there seems to be a good reason for that, though, right? Because what's your impact if you live a half mile down the road?
Well, the difference in Austin is that in the same area where you might only have 2 or 3 houses in Weston, here you have 10. So it's not a matter, as Judge Sikora pointed out, incremental changes, the exceptions will negate the rule. I mean, when you have 10 houses in one block, as you do in Austin, and you say, well, this house that's 2 doors down for me, I don't have standing because I'm surrounded by 3 families anyway, so what difference does it make? I mean, you can say that to every house in the neighborhood. And so by the end of
the
it...
one directly next door or across the street or a butter to the butter within 300 feet. You can't say it to them because they do have standing, right?
No, they wouldn't.
48, Section 11, those folks have standing.
Well, no, it's not. It's only 2 abutters. You can't, if you're the third abutter, it doesn't matter if you're within 300 feet. It's an abutter to an abutter or the person across the street. So, I mean,
but if you're an abutter to an abutter and you're 301 feet away, you're out of luck.
Right, but if you're the third abutter greater than 300, within 300 feet, you're still away.
Right.
I mean, so it's essentially just 2 abutters on the side and the abutter across the street. So even if you're in Weston or something and it's a small lot, so you only might have 4 or 5. But the difference is in the city of Boston here, you have 10 houses. And even if they can make the same argument for the person next to me, sure, even if they have presumptive standing, but they can argue that I'm not an aggrieved person because adding 2 more units to a house next door to me when there's only 3 units, the difference is going to be de minimis. I mean, you can say that to every piece of property. I mean, that was a mistake I made here when they gave 27 Houghton Street 5 variances to go multifamily. I was across the street from that. I should have challenged it, but no one wants to go to court when they don't have to. I mean, that's one of the advantages they have. So I don't go to court. And next thing I know, now they're giving 8 variances, 21 Houghton Street, 3 variances, 8 variances to 9 to 11 Houghton Street, 3 variances to 21 Houghton Street. Why stop there? Why not get a few more to 28? Why not 16? I mean, that's the difference between the Boston zoning code and the state code, Chapter 40. That's why the Boston zoning code specifically says that maintaining the harmony, reducing congestion.
Can I say the respondents claim both that your assertion of a conspiracy relies only on, it looks like, an article written by not yet then Mayor Wu, some report at Cornell, and a law review article, and there are no facts alleged. What's your response to that?
I'm not alleging a conspiracy. I'm alleging a practice and procedure, and the practice and procedure is admitted in all 3 of them. It's not the one by then Councilor Wu was an internal one. The second one that just was issued last September of last year was also an internal one. It was done by an outside contractor, but it was internal. And then the third one was done by Suffolk University. And the procedure is, as the executive director said, half the cases they submit to the zoning board doesn't meet the requirements for a variance, but they issue them anyway. So the practice and procedure is that they're using what's supposed to be a judicial, quasi-judicial board as a legislative body. And that's what Judge Sikora said in his decision, that they're just issuing these variances. They're quoting statutory language that's just pro forma. They don't meet any of the strict requirements for 665 variance. Again, not 40A. variance. The 665, the Boston zoning code specific requirements, which are stricter than the state requirements. They not only want demonstrable harm, they not only want harm, but they want it to be demonstrable, and and it's got to be proof that the variance is required so that the lot owner can have reasonable use. And all these variants that are in the record, I mean, none of those requirements are met. If I have standing, all the variances are invalid on their face, because all they do is quote statutory language, and there is no basis to conclude that forcing an owner to operate a three-family in a three-family zone neighborhood is unreasonable. I mean, that's the whole point of zoning, is to create three families.
Do you agree that if we don't agree with your interpretation of 665, that you are outside 150 or 300 feet of the property?
I'm within 300 feet. The 150, I'm within 150, yes.
You are within 150?
Yeah, that's specifically pled, and if I...
Where was that pled?
Off the top of my head, I don't remember, but
In your complaint,
Correct,
which was amended, you talk about that the 3 or 4 properties are all within the plaintiff's 300 feet long neighborhood on Holden Street, and then in paragraph 3, you say that you are an owner of property that is located 150 feet from Project 1 and directly across the street from Project 2.
Correct, Judge. You remember it better than I do. I'm sorry. Correct. Yeah, the whole block is 300 feet long, and I'm in the middle of the block, so I'm pretty much within 150 feet of everything. But correct, right? So, right. I mean,
even if we disagree with your interpretation of 665, you say you still have standing under 40A because you're within 150 feet of Project 1 and directly across from Project 2?
Well, no, then the issue becomes whether you're a person aggrieved. I mean, once you get away from presumptive standing, in theory, even a person who's a mile away can establish person aggrieved standing if there's some kind of, I don't know, they're going to be firing rockets in the air and they're going to land in your yard or something. So even if you're a mile away, you can establish person aggrieved standing. And I think, regardless of the presumptives, I'm still a person aggrieved, because they're using these variants, 16, 17 of them, to change the density from three-family to multifamily.
Just a moment, I'll see if any follow-up questions. No. Okay, no follow-up questions, and your time is up, so you have to rest on your brief with respect to any remaining arguments. They're not waived.
Thank you.
Thank you.
Good morning, members of the panel, and may it please this court. My name is Thomas Broom, and I'm here on behalf of the appellee, the City of Boston Zoning Board of Appeal. At its heart, this case is simply a zoning appeal. It's just one in which Mr. DiViacchi has alleged that the zoning board granted these variances as the result of a 75-year conspiracy to deprive the citizens of the City of Boston and himself of their constitutional rights. The Superior Court correctly determined that Mr. DiViacchi failed to state any claim that the board deprived anyone of their constitutional rights. And the Superior Court also correctly held that Mr. DiViacchi lacks any standing to challenge these zoning relief granted here. Turning to Mr. DiViacchi's zoning claim, he lacks a presumption of standing, although he does argue for two reasons that he has a presumption of standing. First, that he is within 300 feet of the property, and second, that he received mailed notice from the board. Now, this court, we talked a little bit about whether 40A or whether the Boston Zoning Enabling Act applies. This court in Porter v. Zoning Board Appeal of Boston held that the presumption of standing as articulated under the case law in Chapter 40A applies equally under the Boston Zoning Enabling Act because of the similarity in language in the two statutes. So, and this court already addressed both of these questions, that an abutter to an abutter that is within 300 feet does not have a presumption of standing under Murrow v. Esch Circus Arts, and also that when you receive mailed notice, that does not grant you standing. So this court has already decided both of those issues. There is no reason to now say that the interpretation of presumption of standing under the Boston Zoning Enabling Act is different than that under 40A, because the court has already ruled that it's the same.
You're saying Porter pretty much covers the standing issue from your perspective?
Porter, yes, and then Porter says that the presumption of standing analysis under Chapter 40A applies to the City of Boston, and then Murrow is the one that deals with the specific arguments that Mr. DiViacchi makes in this case. Turning to, again, his allegations of aggrievement, Mr. DiViacchi alleges 12 potential injuries here. All of them are conclusory, none of them are specific, none of them are particularized. In order to have standing as a person aggrieved under the Boston Zoning Enabling Act, you must plead an injury that is, and I will quote, Your Honor, an injury that is causes, or the zoning relief that causes or threatens with reasonable likelihood a tangible and particularized injury to a private property or legal interest protected by the zoning law. Several of Mr. DiViacchi's alleged injuries are not protected by the Boston Zoning Code. In particular, this is Article 51, Section 1, which states the purposes of the Allston-Brighton Neighborhood District, and a copy of that is available at page 78 of the addendum to Mr. DiViacchi's brief. But essentially,
Of the 12, are there some that would be reasonably considered?
protected interests, Your Honor? Theoretically, Your Honor, yes. Things such as noise, traffic, trash, rodents, density, privacy are all theoretically interests that are protected by the Boston Zoning Code. It's just that in this particular case, Mr. DiViacchi has failed to plead any facts that these injuries are particularized to his property. And a particularized injury is an injury that is special or different from the concerns of the rest of the community. And, it requires allegations that the injury is particular to the plaintiff and not to the neighborhood in general. If you look at paragraph 1 of the amended, yes, Your Honor.
Your position would be that density, an increase in density would not be particular to this situation because it would affect the entire street and the entire neighborhood.
Yes, Your Honor. What Mr. DiViacchi is referring to is this incremental impact of density theory, and this court has addressed that theory before. It does require essentially two elements. The first element is one, that the surrounding neighborhood is actually denser than the underlying zoning permits. And then the second element is that the subject property, so Mr. DiViacchi's property in this case, has a special relationship to the property that has received zoning relief. In essence, this was addressed by this court in Bertrand v. Zoning Board of Bourne, I believe. And in that case, what happened was that there was an individual who owned a single-family home. There was a variance granted to the property behind him to build 2 single-family homes immediately abutting the rear of his lot. And in that case, this court held that he had a special relationship to that property and that increase in density was a particularized injury. And recently, this court dealt with the same theory in McNutt v. Boston Zoning Board of Appeal in 2024. It is an unpublished decision. But in that case,
in those cases, I don't believe that in either one, I don't know about the unpublished decision, actually, there was not just one variance, one structure, but there was just one, and here there's the potential for more than one structure to be changed.
In the Bourne case and in the McNutt case?
Yes.
In the McNutt case, I believe there was going to be 2 houses instead of 1 house. Right. The McNutt case was, again, increasing, I think it was a single family into a 2-family home.
Right, but there was only one structure that was being changed, one building that was going to be changed.
Yes, Your Honor, it was only one structure.
And here the allegations are that there's more than one multifamily home that's going to be changed and be increased up to 3 to 5 units or some other combination in the same area, same neighborhood.
Yes, Your Honor. I think what is under appeal before this court today is the zoning relief that was granted to 9 to 11 Holton Street. There's ongoing litigation with regards to 21 Holton Street. And as Mr. DiViacchi has said, he did not appeal the relief to 27 Holton Street. That goes to the first element of the analysis, whether the neighborhood itself is denser than the zoning regulations allow. It doesn't go to the second element, which is whether Mr. DiViacchi's property has a special relationship to the subject property. In this case, there is no special relationship because of the distance that Mr. DiViacchi is from the subject property. The facts of Bourne, like as I said, it immediately abuts the rear of that property. Similarly, in McNutt, this court dealt with not an immediate abutter, but someone who also had a presumption of standing. In that case, their neighborhood received a variance to increase the single family to a 2-family home. And this court, and I will say that this was about whether the private defendant could rebut the presumption of standing that this homeowner already had. So value is not exactly on point here, but it certainly defines the outer scope of what this special relationship looks like. Essentially, this kind of incremental impact theory is only available to those that have a presumption of standing. And in any event, even if this court were to conclude otherwise, Mr. DiViacchi has not pled any specific facts that would let this court reach the conclusion that he has a special relationship with the subject property at 9 to 11 Holton Street here.
All right.
In addition to not being particularized, most of these allegations regarding his injuries are also de minimis, and they are also speculative. You know, a non-speculative injury is a qualitative, or well, requires qualitative or quantitative information that a reasonable person could rely on to conclude that their consequences would actually flow, and then de minimis means that there's actually some kind of impact that's substantial enough to require relief. That with respect to noise, traffic, trash, rodents, privacy. There's no allegation here that explains how granting zoning relief to add 2 additional units to a 3-family property across the street and 3 lots away actually has a specific impact to Mr. DiViacchi's property. Turning to the federal claims, the 1983 claims, Mr. DiViacchi needs to allege that there is actually state action and that there was actually a constitutional deprivation by the government. And in particular, with respect to municipalities, Monell, which is a Supreme Court case, requires that there are only 2 theories that a municipality can be subject to 1983 liability under. One is direct liability for the unconstitutional practices of policymakers. The second is the custom or practice theory. And a custom or practice claim, which is essentially vicarious municipal liability, requires that the policymakers have constructive knowledge of a practice by employees and do nothing to change it, and that the practice is the actual driving force behind the constitutional deprivation. We talked a little bit today already about whether Mr. DiViacchi has pled sufficiently any kind of custom or practice. What he is actually arguing is for a conspiracy here. It stretches back 75 years across multiple administrations, different appointees and different boards, and it essentially says that prior to the existence of the Boston Zoning Enabling Act, there has always been a conspiracy in the city of Boston to not follow the zoning law. He has not done so, but even if this court were to conclude that he has successfully pled the existence of some kind of a custom or practice claim, that is only the first step. He still has not pled that the board has actually deprived him of his constitutional rights. You know, he has 4 theories. 1, a procedural due process violation. 2, the so-called a sham hearing claim that he's made. 3, a substantive due process claim. And 4, an equal protection or spot zoning claim. With respect to his procedural due process claim, it's unclear under Massachusetts law whether an abutter here has a protected property interest, but even assuming that they do, the board provided Mr. DiViacchi notice of this hearing. He attended the hearing. He spoke at the hearing. He confirmed again when he was called that he had nothing further to say, and he submitted written opposition beforehand. First Circuit Court of Appeals is clear that there is no judicial style kind of cross-examination or judicial style hearing required in these kinds of hearings, and this very clearly meets the minimum process that was required. In addition, there is the state appellate process that we're currently engaged in to also protect his rights, which is relevant. The sham hearing claim, again, there's no facts to suggest that this was a sham hearing. First Circuit has addressed this generally in the theory that if there are facts to show that the board is either prejudiced against Mr. DiViacchi or some way uniquely prejudiced for the developer, that he might have a claim. In general, the Supreme Court has said that there is a presumption of validity and constitutionality to these kinds of hearings, and Mr. DiViacchi has pled no facts to overcome that presumption. With respect to the substantive due process claim, in the First Circuit here, in order to plead a substantive due process claim in a land use context, in this kind of municipal permitting context, and you have to allege a conscious shocking conduct by the government. There are no facts here that shocked the conscious. Again, all Mr. DiViacchi relies on in opinions. He calls them audits of the board, internal audits. These are opinions of people that are not formally affiliated with the Zoning Board of Appeal at the time those things were authored. They are all opinions. There are no facts. And if this court wants to see what a substantive due process kind of conspiracy claim looks like, they need to look no further than Brockton Power LLC v. City of Brockton, which is a District of Massachusetts case in which Judge Sorokin upholds a well-pled substantive due process conspiracy in this land use conscious that is in fact conscience shocking. And even if Mr. DiViacchi has pled that the board has, or even if the court were to conclude perhaps that the board had arbitrarily and capriciously issued these variances, that isn't a substantive due process violation. And this court has held that previously in Rosenfeld v. Board of Health of Chilmark. It wasn't specifically zoning relief, but it was specifically related to variances that the board granted for a sewer system. And then finally, the last claim, which is spot zoning or equal protection. Under that analysis, which is the SJC and KISV Board of Appeals of Long Meadows, local zoning boards act in a quasi-judicial capacity, not in a legislative one, and that they are not capable of spot zoning. And this court has similarly held in Ricker variances are equally subject to the same analysis. Thank you.
Questions? Thank you very much.
Thank you, Your Honor.
Counselor?
Good morning. I represent the private party defendant, Patrick McKenna. Looking at the plaintiff's complaint, it appears fairly obvious that this is a challenge to the general practice of the City of Boston or the Board of Appeals, not really a zoning appeal under Section 11 of the Boston Zoning Enabling Act. Maybe this would be a case that could be brought as a 10 taxpayer suit, a mandamus case. Maybe it's a ballot box issue. Maybe it's not even really a case that should be brought in court. But what it's not is an appropriate appeal of my client's project. The plaintiff is not entitled to use a zoning appeal as a basis to vindicate the underlying zoning code in a given district in the absence of establishing standing for the appeal that he's brought. Standing requires actual aggrievement, palpable and unique to the plaintiff, that arises out of a zoning protected interest. There are no facts pleaded in two attempts, two bites at the apple, an original complaint and an amended complaint before the Superior Court to establish standing. We've already covered that there's no presumption of standing here. I won't get into that. There are words used in the complaint that in an appropriate case might give rise to standing, not this case, because there are not facts to back up these allegations. I guess I would slightly disagree with my brother about what in the complaint could give rise to a zoning claim. I think there really are only four things that possibly could give rise to a zoning claim. We talked about the density issue. I'm not going to recover that. I think that was covered. There's traffic that's raised, there's noise, and there's privacy. There's no facts whatsoever to establish that there's any traffic issue that would arise out of this project. This is a project that provides 8 off-street parking spaces. There's no evidence to indicate, there's no allegation to indicate that there's going to be any increased traffic issue arising from this project. Mr. DiViacchi's property has a long driveway and a garage. There's no allegations that he relies on street parking or that there's even an existing traffic issue. As to noise, there are no allegations in the complaint that would indicate that there's going to be a noise problem that arises from this particular project that would affect Mr. DiViacchi. Again, he lives across the street, 3 doors down. There's really no fact in the complaint that would tie this project to some noise impact that's going to affect Mr. DiViacchi, uniquely indifferent from anyone else in the neighborhood. And then finally, as to privacy, again, across the street, 3 doors down, Mr. DiViacchi has a large tree in his front yard. During most of the year, it's doubtful that he can even see the project from his property, never mind a type of privacy concern that would give rise to a zoning appeal, something like being within the setbacks to build a project, something that's overly large for a property, where there's windows that are facing other windows of the adjacent property, where there's going to be some legitimate privacy concern, or overlooking a backyard. None of those facts are here, and so we submit, based on the record, based on the Superior Court judge's decision, this court should affirm. Thank you.
Thank you very much.